Imagine this. The year is 1973. India's Supreme Court is packed. The tension is electric. On one side, the most powerful parliament in the world, with a two-thirds majority, claiming it can change anything in the constitution. On the other side, 13 Supreme Court judges, sitting in the largest constitutional bench ever assembled in Indian history. The question before them. Can Parliament destroy the very constitution it swore to protect? That one question, answered in the Keswananda Bharti case of 1973, gave birth to what legal scholars call the most powerful judicial doctrine in the world. The basic structure doctrine. And before we get there, we need to understand how the constitution is amended, what Article 368 says, and how the greatest battle between Parliament and the judiciary unfolded over decades. This is a mega lecture, covering Chapter 10 and Chapter 11 of Laxmikanth in one complete, cinematic, exam-ready session. Before we begin, the complete PDF notes for both these chapters are available on our Telegram channel. The link is in the description below. Join right now before you forget, because everything you see in this video is available there for free revision. Telegram link in the description. Now, let us begin. Why does the Constitution need amendment? Think of the Constitution as a living document. Not a museum piece, a living, breathing framework for governance. When our Constitution was written in 1949, India was a newly independent nation dealing with the challenges of partition, poverty, and nation building. Could the framers have predicted everything India would face in 2024? Of course not. That is exactly why Laxmikanth says, the Constitution of India provides for its amendment in order to adjust itself to the changing conditions and needs of the society. But here is something beautiful about our Constitution. It is neither too flexible like Britain's, where Parliament can change anything with a simple majority, nor too rigid like America's, where even small amendments require massive consensus. India's constitution is a synthesis of both, some parts easy to change, some parts harder, and some parts requiring even state ratification. Now, Article 368 in Part XX of the Constitution deals with the power of Parliament to amend the Constitution and its procedure. It states that Parliament may, in the exercise of its constituent power, amend by way of addition, variation, or repeal any provision of the Constitution. Three keywords: addition, variation, repeal. Parliament can add new provisions, modify existing ones, or remove provisions entirely. But, and this is the big but, Parliament cannot amend those provisions which form the basic structure of the Constitution. This was ruled by the Supreme Court in the Keswananda Bharti case of 1973. We will come to that, but first, let us understand the amendment procedure itself. Procedure for amendment. Now let us go through the amendment procedure step by step. This is directly asked in prelims, every single step matters. Step 1. Introduction of the bill. An amendment bill can be introduced in either House of Parliament, Lok Sabha or Rajya Sabha. It can be introduced by a minister or by a private member. And here is an important distinction: unlike money bills, an amendment bill does not require prior recommendation of the President. It can be introduced directly. Amendment can be initiated by either House of the Parliament to the Constitution. Remember this. Step 2. Special majority in each House. The bill must be passed in each House by a special majority. Special majority means two conditions both must be met simultaneously. 1. A majority of the total membership of the House. Not just those present, the total members. 2. A majority of two-thirds of the members of the House present and voting. So if Lok Sabha has 543 members, the bill needs more than 271 votes, majority of total, and two-thirds of those present and voting. Both conditions together. That is special majority. Step 3. State ratification, for federal provisions. My handwritten notes clearly state, the constitutional amendment bill must be passed by both Houses of Parliament separately by special majority, Art. 368. If the amendment seeks to change federal provisions of the Constitution affecting the relationship between centre and states, it must also be ratified by the legislatures of at least half the states, by a simple majority. Note, the states give their consent by simple majority. It is only Parliament that uses special majority. Also, there is no time limit within which states must ratify. And states cannot withdraw their ratification once given. Step 4. Presidential assent. After passing both houses and state ratification where needed, the bill goes to the President. And here is a very important point from the handwritten notes. The President's power to veto a bill for amendment of the Constitution has been taken away by substituting the word shall give his assent by 24th Amendment Act. This is critical. The 24th Constitutional Amendment Act of 1971 made presidential assent mandatory. The President cannot withhold assent. Cannot return the bill for reconsideration. Must sign it. Period. Step 5. It becomes law. After presidential assent, The bill becomes a constitutional amendment act and the constitution stands amended accordingly. Also, very important, there is no provision for a joint sitting of both houses in case of a deadlock on an amendment bill. Unlike ordinary bills where Article 108 provides for joint sitting for constitutional amendment, if one house rejects, the bill simply fails. No joint sitting allowed. 3 types of amendments. Type 1, simple majority. Some provisions of the Constitution can be amended by a simple majority of Parliament, just like ordinary legislation. Simple majority means a majority of members present and voting. And here is the crucial point, these are not treated as amendments under Article 368. They are technically ordinary legislative acts, even though they change constitutional provisions. Article 2 and 3, admission or establishment of new states. Formation of new states and alteration of areas, boundaries, or names of existing states. Abolition or creation of legislative councils in states. Second schedule, emoluments of president, governors, speakers, judges. Quorum in parliament. Salaries and allowances of MPs, rules of procedure in parliament. Privileges of parliament, its members and committees. Use of English language in parliament. Number of puisne judges in the Supreme Court. Conferment of more jurisdiction on the Supreme Court. Use of official language. Citizenship acquisition and termination. Elections to Parliament and state legislatures. Delimitation of constituencies. Union territories. Fifth schedule, administration of scheduled areas. Sixth schedule, administration of tribal areas. Type 2, special majority, Article 368. The majority of constitutional provisions are amended by special majority, total membership majority plus 2/3 of members present and voting. This covers fundamental rights, directive principles, and most other constitutional provisions. Type 3, special majority plus half states ratification. The most complex type, used for provisions that touch the federal structure. Parliament passes with special majority, and at least half the state legislatures also ratify by simple majority. Election of the President. Extent of executive power of Union and states. Supreme Court and High Courts. Distribution of legislative powers between center and states. Seventh schedule, the Union list, state list, and concurrent list. Representation of states in Parliament. Article 368 itself, yes, even the article about amendments can be amended only with state consent. And the GST Council. Remember, Article 368 itself falls in Type 3. This means even the procedure for amendment is protected by the highest level of amendment process. Important constitutional amendments. These come in prelims almost every year, at least 1 to 2 questions directly. First Amendment Act, 1951. This was the very first amendment to the Constitution. My handwritten notes say, the first amendment bill to Constitution was presented in 1951, added to new Articles 21A and 21B, and 9th Schedule for protection of agrarian reforms. The 9th Schedule was created to protect land reform laws from judicial challenge. 24th Amendment Act, 1971, overruled the Golaknath case. Affirmed that Parliament can amend any part of the Constitution including fundamental rights. Also made presidential assent to constitutional amendment bills mandatory. 25th Amendment Act, 1971, my handwritten notes state 25th Amendment Act 1971 provided that a law passed to give effect to DPSP in Art 39B and 39C shall be void that it abridges the rights conferred by Art 14, 1931. Essentially gave DPSPs some protection against certain fundamental rights. 39th Amendment Act, 1975. 39th CA inserted Article 329A to immunize PM's election from judicial review. The election of President, VP, and PM could not be challenged in the Supreme Court. This was later struck down in the Indira Gandhi case. 42nd Amendment Act, 1976. This is called the Mini Constitution by 42nd Amendment Act 1976 is termed as Mini Constitution. It made the most sweeping changes ever, added DPSPs, fundamental duties, declared amendments cannot be challenged in court, tried to make Parliament's amending power absolute. Later curtailed by the Supreme Court. 44th Amendment Act, 1978, restored the balance after emergency excesses. Curtailed many provisions of the 42nd Amendment. 69th Amendment Act, 1991, notes say, 69th Amendment Act 1991 provided the status of National Capital Region to Delhi. 86th Amendment Act, 2002, the Constitution Amendment Bill dealing with free and compulsory education for all children between 6 to 14 years. 91st Amendment Act, 2003, notes mention, limiting the size of Council of Ministers. This Act limited the size of the Council of Ministers including the PM to not more than 15% of the total strength of Lok Sabha. 93rd Amendment Act, 2005, Notes state, 93rd Constitutional Amendment 2005, the OBC have been given 27% reservation in admission to educational institutions. 97th Amendment Act, 2011, notes say, right to form cooperative societies under Art 19, 1, c. 99th Amendment Act, 2014, notes mention, formation of National Judicial Appointments Commission. But the Supreme Court struck down this act as being violative of independence of judiciary, a basic structure element. Notes specifically record, the SC struck down 99th Amendment Act as being violative of independence of judiciary. 101st Amendment Act, 2016, GST, Goods and Services Tax, the biggest tax reform in India's history. 103rd Amendment Act, 2019, 10% EWS, economically weaker section, reservation. The 42nd Amendment Act has a special note, it is called the mini-constitution because it made the most comprehensive changes. Criticism of amendment procedure. Every system has critics. Let us hear what critics say about India's amendment procedure. Criticism 1. No special body. In the USA, constitutional amendments are handled by a special constitutional convention, a body separate from the regular legislature. In India, there is no such special body. The power to amend the constitution lies solely with Parliament. Critics say this gives Parliament too much power over the constitution it is supposed to be governed by. Criticism 2. States cannot initiate. This is a significant criticism. The power to initiate an amendment belongs exclusively to Parliament. No state legislature can initiate a constitutional amendment. My handwritten notes capture this. The power to initiate an amendment to the Constitution lies with the Parliament. The state legislatures cannot initiate any bill or proposal for amending the Constitution. Criticism 3. Limited state role. State legislatures can only ratify, not initiate, not deliberate deeply, not propose changes. Their role is passive, yes or no on Parliament's proposals. Criticism 4. No joint sitting for deadlock. If Lok Sabha and Rajya Sabha disagree on an amendment bill, there is no provision for a joint sitting. The bill simply dies. This can create a constitutional deadlock. Criticism 5. Too similar to ordinary legislation. Critics argue that constitutional amendment procedure is too similar to ordinary legislative procedure. Except for the higher threshold, the process feels the same. Criticism 6. Ruling party dominance. Since Parliament controls the entire process, a party with a two-thirds majority can potentially change the constitution according to its own ideology, which is a democratic concern. However, and this is the important counter, despite these criticisms, the amendment process has proved itself wise and balanced over 75 years. K.C. Weir, the constitutional scholar, said it strikes a good balance between flexibility and rigidity. And as Jawaharlal Nehru said, if you make a constitution too rigid and permanent, you stop the nation's growth. The constitution should be a living, vital, organic document. Chapter 11 begins, the battle begins. We now enter Chapter 11, and this is where the story gets truly cinematic. Imagine a tug of war. On one end, Parliament, elected by the people of India, claiming absolute power to amend the constitution in the name of social justice and welfare. On the other end, the Supreme Court, guardian of the constitution, arguing that some things are beyond even Parliament's reach. This battle between the legislature and the judiciary lasted nearly 3 decades. From 1951 to 1980. And it produced one of the most extraordinary legal doctrines in the world, the Basic Structure Doctrine. The core question was simple but profound. Can Parliament amend Article 368 to amend away the fundamental rights? Can it destroy the very rights it gave to citizens? Parliament said yes. We have unlimited power. The people gave us this mandate. The Supreme Court said no. Power has limits. Even democratic power. Even constitutional power. Who was right? Let us follow the timeline, case by case, and watch this drama unfold. Buckle up. This is constitutional history at its most dramatic. Case timeline, 1951 to 1980. Now let us walk through this timeline, case by case. This is the most important section for both prelims and mains. Learn each case, each ruling, and the constitutional consequence. Act 1, 1951, Shankari Prasad case. The very first year after the constitution came into force. The question, can Parliament amend fundamental rights? The Supreme Court said yes. It ruled that an amendment under Article 368 is not law within the meaning of Article 13. Article 13 says the state shall not make any law that takes away fundamental rights. The court said amendment is not law, so Parliament can amend fundamental rights. Parliament wins round 1. Act 2, 1964, Sajjan Singh case. The Supreme Court simply reaffirmed Shankari Prasad. Parliament can amend FRs, Parliament wins again. Act 3, 1967, Golaknath case. This is where the plot turns dramatically. The Supreme Court reversed its earlier stand. A landmark 11-judge bench ruled, a constitutional amendment is law under Article 13. Therefore, Parliament cannot amend fundamental rights. FRs are sacrosanct beyond Parliament's reach. Parliament loses. FRs are protected. This created a constitutional crisis. Parliament was furious. Act 4, 1971, 24th Constitutional Amendment Act. Parliament strikes back. In direct response to Golaknath, Parliament passed the 24th Constitutional Amendment Act. This act overruled Golaknath legislatively. It declared that Parliament has the power to amend any part of the Constitution including fundamental rights. It also made presidential assent to amendment bills mandatory. Parliament reclaims supremacy through legislation. Act 5, 1973, Keswananda Bharti case, the big one. 13 judges. The largest constitutional bench in Indian history. The case that changed everything. The Supreme Court upheld the 24th Amendment. Yes, Parliament can amend fundamental rights. But and here is the world-changing but Parliament cannot alter or destroy the basic structure of the Constitution. The basic structure doctrine was bold. Parliament can amend, but cannot destroy the soul. It can change the Constitution, but cannot eliminate what makes India, India. My handwritten notes capture this perfectly. Keswananda Bharti case 1973, Parliament can amend any part of Constitution, but cannot alter basic structure. Act 6, 1975, Indira Nehru Gandhi case. The Supreme Court applied the basic structure doctrine in this case. Held that free and fair elections are part of the basic structure. The 39th Amendment Act, which tried to immunize the Prime Minister's election from judicial review, was struck down. Parliament cannot use Article 368 to protect its own members from constitutional challenges. Act 7, 1976, 42nd Constitutional Amendment Act. Parliament tries again, this time more aggressively. The 42nd Amendment declared that constitutional amendments cannot be challenged in any court. It claimed Parliament's amending power has no limitation. It tried to override the basic structure doctrine completely. 42nd CAA, 1976 inserted clauses 4 and 5 in Article 368 declared that constitutional amendments cannot be challenged in court and affirmed Parliament's amending power has no limitation. Final Act 1980 Minerva Mills case, the resolution. The Supreme Court gave its definitive answer. It struck down clauses 4 and 5 of Article 368 inserted by the 42nd Amendment. It ruled limited amending power itself is a part of the basic structure. Judicial review itself is a part of the basic structure. Parliament cannot use Article 368 to destroy the basic structure. The balance between fundamental rights and directive principles is an essential feature of the Constitution. The conflict is settled. The basic structure doctrine stands. Parliament has power, but not unlimited power. This is the present constitutional position. SC in Minerva Mills case 1980 that preference is given only to DPSP mentioned in Art 39b and 39c over FR mentioned in Art 14 and 19. Basic structure doctrine. What exactly is the basic structure? The basic structure doctrine says there are certain fundamental features of the Constitution so essential to its identity and democratic character that even Parliament cannot touch them. Not under Article 368. Not under any power. These are beyond the reach of every constitutional authority, including Parliament itself. The Supreme Court has never given a complete, final, closed list of what constitutes the basic structure. Instead, case by case, the court has identified elements that qualify. Supremacy of the Constitution. Sovereign, democratic, republican nature of India. Secular character. Separation of powers between legislature, executive and judiciary. Independence of the judiciary. Judicial review, the power of courts to examine laws. Federal character of the Constitution. Rule of law, all persons equal before law. Harmony between fundamental rights and directive principles. Unity and integrity of the nation. Free and fair elections. Parliamentary system of government. Freedom and dignity of the individual. Welfare state, socio-economic justice. Powers of the Supreme Court under Articles 32, 136, 141, and 142. Powers of High Courts under Articles 226 and 227. Limited power of Parliament to amend the Constitution. Principles or essence underlying fundamental rights. Effective access to justice. Principle of equality. Now this list is important, but remember, the Supreme Court has not said this is the final, exhaustive list. New cases may add to it. What the court has said is if Parliament tries to amend the Constitution in a way that destroys the essence of any of these, the Supreme Court can declare that amendment unconstitutional and void. Think of it this way, imagine the Constitution is a building. Parliament can renovate it, add floors, repaint walls, change rooms. But Parliament cannot demolish the foundation. The basic structure is the foundation. It cannot be touched. Case-wise basic structure elements. The basic structure doctrine has been applied and expanded across dozens of Supreme Court cases. Let me walk you through the most important ones from the textbook. Keswananda Bharati, 1973, the founding case. Declared supremacy of the Constitution, Republican and democratic form of government, secular character, separation of powers, and federal character as basic structure elements. Indira Nehru Gandhi case, 1975, known as the election case. The 39th Amendment had tried to prevent courts from examining the PM's election. The Supreme Court struck it down, declaring free and fair elections and rule of law as basic structure elements. Judicial review was applied here as a basic structure concept. Minerva Mills, 1980. Struck down clauses of the 42nd Amendment. Declared limited amending power of Parliament and judicial review as basic structure. Also declared that harmony between fundamental rights and DPSPs is a basic structure element. L. Chandrakumar, 1997, held that powers of high courts under Articles 226 and 227, the writ jurisdiction, is part of basic structure. Cannot be taken away. 99th Amendment case, NJC, 2015, when Parliament tried to replace the collegium system with the National Judicial Appointments Commission, the Supreme Court struck it down, reaffirming that independence of the judiciary is an unalterable basic structure element. 38th Amendment Act, curtailment of the power of judicial review. This was the 38th Amendment which tried to limit judicial review, which was later addressed through subsequent cases. The key takeaway: every time Parliament tried to go beyond the basic structure, the Supreme Court pulled it back. The doctrine has proven itself as the ultimate guardian of constitutional democracy. Present constitutional position. Let me state it clearly because this is what you write in UPSC mains. Position 1. Parliament can amend any part of the Constitution, including fundamental rights, under Article 368. This power is confirmed by the 24th Amendment and upheld in Keswananda Bharati. Position 2. But Parliament cannot alter or destroy the basic structure of the Constitution. This is the Keswananda Bharati ruling, and it stands as the definitive position. Position 3. Parliament can amend fundamental rights for the purpose of implementing directive principles, as long as it does not damage the basic structure. The harmony between FRs and DPSPs must be maintained. Position 4. The limited amending power of Parliament is itself a basic structure element as declared by Minerva Mills. So even trying to give Parliament unlimited amending power is unconstitutional. Position 5. Judicial review of constitutional amendments is part of the basic structure. Parliament cannot by any amendment exclude constitutional amendments from judicial review. So in summary, Parliament has power. Parliament has significant power, but not unlimited power. The Constitution's basic identity, its soul, is protected by the basic structure doctrine upheld by the Supreme Court, and it cannot be destroyed by any parliamentary majority, however large. My handwritten notes beautifully summarize, SC, in Minerva Mills case 1980 that preference is given only to DPSP mentioned in Art 39b and 39c, over FR mentioned in Art 14 and 19. This is the limited override, not a blanket one. Dr. B.R. Ambedkar himself observed, the Constituent Assembly refrained from putting a seal of finality and infallibility on the Constitution. The right to amend the Constitution is there, but not the right to destroy it. Exam traps plus PYQ references. Now let us go through the most common exam traps, because UPSC loves to test these exact misconceptions. Trap 1. Simple majority is equal to Article 368. Simple majority amendments like creating new states, changing MP salaries, altering union territories, these are not Article 368 amendments. They are ordinary legislation. Never confuse them. Trap 2. Joint sitting for amendment bills. No. 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 Joint sitting under Article 108 is for ordinary bills. For constitutional amendment bills, there is no joint sitting provision. If one house disagrees, the bill fails. Trap 3. States can initiate amendments. Absolutely not. Only Parliament, either house, can initiate. State legislatures cannot propose constitutional amendments. They can only ratify when required. Trap 4. President can veto amendment bill. Before 1971, there was ambiguity. After the 24th Amendment, the President must give assent. Cannot withhold. Cannot return. Mandatory. Trap 5. Basic structure is a fixed list. Wrong. The Supreme Court has never given a complete, exhaustive, closed list. New cases can add to the basic structure. It is an evolving doctrine. Trap 6. 42nd Amendment gave permanent unlimited power. The 42nd Amendment tried to, but the Minerva Mills case, 1980, struck that down. Parliament does not have unlimited amending power. Trap 7. Golaknath still stands. Golaknath said Parliament cannot amend FRs. But Keswananda Bharti, 1973, effectively overruled this through the 24th Amendment upholding. Parliament can amend FRs, but cannot destroy the basic structure. Trap 8 Amendment is equal to law under Article 13. This is a nuanced point. Different cases ruled differently. The settled position after Keswananda is Parliament can amend FRs under Art 368, but cannot destroy basic structure. Art 13 cannot be used to simply void any amendment. Final rapid revision, both chapters together. And that is the story of how India protected its constitution from itself. Parliament got power. But not absolute power. Courts drew the line. The basic structure doctrine is that line. And it has held for over 50 years. Every time someone has tried to cross it, 42nd Amendment, NJC, the Supreme Court has pulled India back. That is the beauty of our constitutional design. Dr. B.R. Ambedkar was right, the constitution should be a living document. It should change. It should grow. But it should never lose its soul. And the Keswananda Bharti case, with 13 judges in 1973, ensured that the soul of the constitution will always be protected. Before I close, the complete PDF notes for both Chapter 10 and Chapter 11 including the amendment table, case timeline, basic structure elements list, exam traps, and PYQ references, are all available on our Telegram channel. The link is in the description. Join right now for free. Share this with your friends preparing for UPSC. Subscribe, hit the bell icon, and I will see you in the next lecture, Chapter 12, Parliament of India. Until then, keep studying, keep questioning, keep going.